Good afternoon, everyone. It's good to welcome everyone. We have a large group of people who are in attendance for the webinar that Nick Scala, my partner and colleague at Conn-Maciel Carey, and I will present today. We are very excited to talk to you about two brand new OSHA chemical standards that have been promulgated over the last couple of years and will kick in full force over the next couple of years. We'll talk a lot about implementation dates, compliance delays, the substance of the rules. We'd like to spend about an hour talking to you almost exclusively about these two rules and their potential impacts on your facilities. Before we get started, let me just mention that Eric Kahn, who is the head of our OSHA practice, along with Nick and I and a number of other of our colleagues, present a webinar about once a month, I think exactly once a month, on various topics that we identify as particularly interesting, hopefully, to a lot of our clients and industry generally, related, of course, to OSHA workplace standards and enforcement. We picked this topic to devote an entire hour to because, as many of you know, OSHA does not promulgate many chemical standards, and these are two new standards, very, very significant, with the Silica Standard in particular having a broad implication across a swath of industries. So we're excited to talk to you today. As Nick mentioned, we're recording this webinar, and we will have it available to you afterwards. And we have the ability to have you all ask questions that Nick will sort of guide us through via the computer system here. All right, well, let's start talking because we've got a lot to cover in just a little bit over an hour. Very, very brief introductions. I'm Kate McMahon. I've talked to many of you before. I have practiced in the area of OSHA and environmental compliance for more years than I care to admit. I have a particular focus and hopefully some insight and expertise in the area of OSHA chemical rulemaking, OSHA rulemaking generally, and I have followed the long history of OSHA's promulgation of both the Silica and Beryllium standards, so I have hopefully some insight that I can share with you all today. My partner, Nick Scala, is an MSHA lawyer. Nick is an expert in all things MSHA, both enforcement, compliance assistance, et cetera, and Nick has been keenly following what MSHA is doing, in particular on the Silica rule making, what will happen there, and Nick will talk some about that as we move into the presentation. There's so much to cover, but we thought that we'd try to focus on the highlights, the most significant aspects of OSHA's rules, and so we put this agenda together. I'll spend a little time, hopefully no more than 10 minutes or so, talking about the history of the rulemakings, not necessarily because the history is relevant to compliance issues that you will face in the future, but because I have to admit that it's difficult to talk about these rules without talking some about the history, because the history of these two rules in particular is very, very fascinating. And to those of you who are out there in the world dealing with the practical application of these rules, it might be useful to you to have some understanding of how these rules ended up being promulgated and when, under the Obama administration and under Dr. David Michaels. I'll talk about the status of the rules, compliance dates, implementation timeframes. Then we will spend a good bulk of time talking about the Silica rule in particular and the nuts and bolts of it, what the major requirements are, how to comply with those requirements in both the general industry as well as construction. We'll talk some about maritime too, but I don't think many of you are from the maritime industry, so we'll focus on general industry and construction. Nick will talk a little bit about the differences between, at least as things stand right now today and what we expect in the near term, silica enforcement by MSHA versus by OSHA. I'll talk a little about the new beryllium standard in particular. The beryllium standard affects far fewer industries and employees, and therefore employers, than the silica standard, so we won't spend as much time on it. Also, I have to note that I represent the major manufacturer in the industry, so we're actively involved in settlement negotiations with the agency, so I'm limited in what I can share, but I can certainly share what is known to the public and focus on those things that are most important to any of you who might have to deal with the beryllium standard in the future. And then finally, I'd like to end with a discussion, just a more general discussion about OSHA chemical rulemaking. What's happened, how it's gotten so, pardon the informality, but how it's gotten so messed up, and what we might expect in the future. All right, well, with that, Nick, have I missed anything to kick us off here? Maybe you could at least do an introduction of yourself, and then I can start talking about the history of the rules.
Yeah, thank you, Kate. I think that was very thorough about what we're going to be covering this hour. I'll be brief, but my name is Nick Scala. I am the chair of the Carey MSHA practice group. As Kate mentioned, my practice is primarily in defense of mining companies and independent contractors in the mining industry, both through compliance assistance, contest work, as well as investigation management, be it special investigations or discrimination claims under the Mine Act, or if we're doing fatality or serious injury investigations. So as part of that, I have dealt with the silica regulations in the MSHA world quite a bit, and in order to really deal with those at this point in time, we have to look at what is happening in the world of OSHA. So I've got some of an understanding based off of what I've been covering on the MSHA side, the effect of how that OSHA regulation is really going to be put into effect, and the enforcement side of it. And so that's what we'll be discussing today. And Kate, I think we're ready for you to kick it off on the historical aspects of these rules.
All right. Thanks, Nick. Okay. So first, just a little bit on beryllium. I don't know how many of the webinar attendees here are participating in the webinar because of the beryllium standard. I'm guessing most of you are here because of silica, so as I said, I won't take that much time, but I do want to give you just a little flavor. The beryllium standard, it's OSHA has estimated, I believe, around 70,000 employees in the United States will be impacted by the beryllium standard. The beryllium, for those of you who don't know, is the lightest, but I believe strongest metal on the face of the earth. It is stronger than stainless steel, it is more flexible, it is light, and it therefore provides great use in myriad of applications across the board. Commercial, I believe that the base in which you plug your cell phone, every one of you on this webinar today, plug your cell phone into charge. I believe that most of those phones will have some sort of copper beryllium alloy that allows that plug to go in there a gazillion times in and out and not bend or break the base. So the beryllium is a critical element that is mined here in the United States and one other location outside the United States, and used not only in these commercial applications like phones, but also in the nuclear weapons, atomic weapons industry. The standard that exists until very recently was a standard of 2 micrograms per meter cubed. That was a standard that came from the Atomic Energy Commission work that had been done in the nuclear weapons industry, and that standard was determined by industry as well as the government over a few decades of time in the middle of the century to be not adequate. OSHA industry collaborated with NIOSH to do some very good studies in the latter part of the century, in the 1970s, I believe, is when this started. But NIOSH did a study that looked not only at the adverse health effect that everyone by this time knew about, chronic beryllium disease and acute beryllium disease, but also to see if beryllium caused cancer. There was a lot of criticism, a lot of question about the study. Industry didn't think it was done well. The government, NIOSH, did. It was the basis for another move by the sister agency, OSHA, to develop a standard in the mid-1970s. According to Fable, that standard was essentially quashed by the Department of Energy and the Department of Defense, putting pressure on the Department of Labor to get rid of the standard because of the necessity of the chemical in the atomic weapons industry. There's a lot of fable there, a lot of myth, but you know, it's a really interesting and frankly salacious background to what sometimes are considered to be pretty drab OSHA standards. The story goes that, you know, there's a famous taxi cab ride where the Secretary of Energy puts pressure on the Secretary of Labor. There's lots of iterations of that story, by the way, but supposedly the standard was squashed. Now, you know, I think we don't need to spend more time on it than that, but you know, there aren't too many stories that result in salacious newspapers about chemical OSHA standards, but this was one of them. The Toledo Blade ran a story in 1999 that was incredibly incriminating of the industry and its participation in this, and a lot of that has been proven to be, you know, exaggerated, but still, that is the background for this for this standard. As time passed, industry continued to work in the area to study the effects, the adverse health effects of beryllium, developed its own workplace safety standard, worked with NIOSH on a couple of collaborative studies, and OSHA in 2003 took up again in a serious way the idea of regulating beryllium below the 2 micrograms per meter cubed limit that existed since the early 1970s, when OSHA first came into existence and took that 1948 AEC standard as a consensus standard, put it in Table Z. 2003, OSHA issues a request for information. A lot of information is submitted, but another decade goes by without any standard. Everybody recognized that the 2 microgram per meter cubed limit was woefully low, industry. In a very unusual and to be accommodated move, industry collaborated with labor union led by the United Steelworkers to develop a model standard. That model standard was provided to OSHA in February 2012 as a model for what a new standard might look like. We'll talk about what it ended up looking like in the specific in a little while. Bottom line, though, it continued to take OSHA quite a long time to take that model standard that both labor and industry agreed on and develop a rule. But ultimately, they did. And 11 days before Donald Trump's inauguration, Dr. Michaels and the OSHA agency promulgated a final rule on beryllium. We'll talk about its details in a little bit. So, long time in coming for sure, from the very origin of OSHA in 1971 until just a few days before Donald Trump took office. How about silica? What's the history there? We don't have, or I'm at least unaware of any salacious newspaper articles like there are in the Toledo Blade and New York Times about beryllium. But on the silica side, we've got an even longer history. And I thought, you know what they say, a video clip is worth 1,000 words, right? So I thought, rather than trying to explain, let me just play a little clip.
and I feel it to be my duty to make this report available to the working people of the United States and to their employers. This report shows how silicosis occurs, where it occurs, and what the disease is. The report emphasizes that these control measures, if conscientiously adopted and applied, that silicosis can be prevented.
I first saw that video clip when Dr. David Michaels played it at a conference that I was attending. Having trouble moving now to my next slide. There we go. And I thought, you know, I was trying to make a joke about a video clip being worth 1,000 words, but in some ways it's very true. To see Frances Perkins, the first Secretary of Labor, I believe that video clip is from 1938, talk about a report that she had on silicosis and about the measures that had been identified that if put in place, pursuant presumably to a standard, a workplace standard, and this is long before OSHA even existed, obviously, silicosis could be prevented. 1938. We have the standard proposed in September of 2013, exactly 75 years after Frances Perkins identified silicosis as a major concern and talked about regulation of it in the workplace. The standard, notwithstanding the fact that, and another interesting nugget about the history of silica, notwithstanding the fact that the rule was promulgated in, was proposed in September of 2013, it was held up under the Obama OMB, under the Obama White House for about 2 years because of concern expressed by industry that it would be tremendously, enormously impactful on industry, and it would not be able to be met without a very, very significant impact economically on a broad swath of industries. Notwithstanding that, ultimately the OMB did release it back to OSHA, and it was promulgated with an effective date of June 2016, so about 78 years after Frances Perkins' little speech there. All right, well, enough of the history of how these standards kind of came to be. Fact of the matter is they both exist. Both standards were challenged by industry. For silica, both industry and labor challenged it. For beryllium, industry challenged it. Labor intervened in those challenges. For silica, let me share with you that we had a decision in September of 2017, just a few months ago, about 6 months ago, that addressed the major challenges, all the challenges brought by industry. Industry challenged this rule on multiple grounds, most significantly on the infeasibility economically and the infeasibility technologically of the rule. Under the OSHA Act, a standard, an OSHA standard has to meet both a technological as well as an economic feasibility standard. Industry's challenge was that, at least for certain segments of industry, it met neither. In addition, as a threshold matter, in order for OSHA to promulgate a standard, it's got to demonstrate that there is a significant risk of material impairment of health associated with the risk associated with what the standard is trying to control, and that by implementing the standard, there will be a reduction in that risk. In addition to those three sort of key challenges, industry challenged it on a couple of other grounds, focused specifically in one instance on the dry sweeping requirement of the standard and on the confidentiality of medical examination information being not shared with the employer, shared directly by the physician with the employee, and not letting the employer know about the results of the medical exam. Finally, there was a process challenge that was brought. In September 2013, 2017, there was a court decision, D.C. Circuit Court of Appeals, addressing all of those challenges. Jackson Lewis was the primary law firm representing industry in those matters, and the court decided wholesale on every one of those industry challenges against industry and allowed the rule to go forward. In addition to the challenges brought by industry that were all rejected by the court, labor challenged the rule on two grounds. One, this 30-day medical surveillance requirement in the construction industry. It gets a little complicated. I won't go into it. And the court rejected that challenge anyway, so it's sort of neither here nor there. The second challenge, though, brought by labor was related to the absence of a medical removal provision. Those of you who are familiar with chemical standards will know that some of OSHA's chemical standards have medical removal provisions. For instance, the beryllium standard has a medical removal provision. Silica does not, and labor challenged on that ground. The court's decision rejected, as I said, all of industry's challenges, the labor challenge related to medical surveillance, but it did remand the rule to the agency for further explanation of why it did not include a medical removal provision. So that one aspect of the rule is still a little bit up in the air. Other than that, however, the rule is now secure from legal challenge. So what that means, of course, is this rule is not only, going into place, but it's already been in place in the construction industry. One thing that those of you who practice in this area will know, but those of you who don't probably don't, is that even when a legal challenge is brought to a standard, that does not automatically stay the standard. The standard continues and will follow the compliance deadlines that are written into the standard. Now, often, in a situation where there's a challenge and there are settlement negotiations going on with the agency will delay those compliance dates, as it did in both of these rules, pending settlement discussions and or some other things. However, the rubber has met the road on Silica, and here we have a chart that essentially describes the compliance dates that there's no sign that these will be disturbed. All right. For general industry, we are just about there. We've got just a couple of months, June 23rd, 2018, when all of the provisions of the Silica Standard will become the rule's already been effective, a couple of years ago, but will become provisions that have to be met, complied with by employers. So employers right now should have already read the rule, understand what needs to be done to comply with the rule, and Nick's going to talk about that in just a minute. The only provision that there's an additional time frame of 2 years to comply with is the implementation of medical surveillance for employees who have exposures above the action level. We'll tell you about the 25 microgram per meter cubed action level in a couple minutes, but below the PEL of 50 micrograms per meter cubed. So under the standard, and this is important, under the standard, if your employees have exposures above the PEL of 50 micrograms per meter cubed and you're in general industry, then you have to comply with medical surveillance. Those employees have to be kicked into a medical surveillance program. However, if they're experiencing exposures below the PEL but above the action level, you've got a couple of additional years to put those workers into your program. The whole point of this is OSHA is trying to give employers a couple of additional years to work on their engineering controls, to lower exposures, so that those exposures of those employees in that target group can get below the action level, in which case medical surveillance will not be required. Okay. For the maritime industry, same thing, June 23rd, 2018, for all provisions except the same one I just described for general industry. Construction industry, all provisions have to be met, had to have been met by June of last year, okay? So those in the construction industry have already been living this rule for nearly a year. There's one piece of it that, there was a little extension of time until this coming June, and that is that when you do exposure assessments under the standard, we'll talk a little bit about that, Section D of OSHA's health standards typically describe both, at least modern standards, describe performance options and scheduled monitoring options. There are a couple of different ways you can assess your exposures of your employees in your workplace. Under the standard, under the Silica Standard, OSHA has promulgated Appendix A, which describes the procedures for analyzing air samples of, respirable crystalline silica, and the quality control procedures that have to be followed by labs. That, because OSHA wanted to give employers some time so labs could come up to snuff with that Appendix A requirement, there was a little delay, but as of June, you as an employer have to make sure, even in the construction industry, you have to make sure that your labs that you're using to analyze silica samples meet the Appendix A requirements. And then finally, OSHA has given an additional time frame delay of enforcement of compliance dates for the hydraulic fracking industry, engineering controls, okay? Engineering controls in the oil and gas industry. Those engineering controls do not have to be in place and implemented until June of 2021. Beryllium, very quickly. Legal challenge was brought to the Beryllium Standard by a variety of industries, both to the maritime and construction standard as well as to the General Industry Standard. Those challenges were all consolidated in the 8th Circuit. There is active settlement negotiations ongoing related to the General Industry Standard and related to the Maritime and Construction Standard. OSHA last year issued guidance that indicated that it was not going to enforce the standard in the maritime and construction industries. And then it issued a notice of proposed rulemaking, and that proposed rule basically eliminates all of the ancillary provisions of the rule for maritime and construction only, leaving only the PEL and the STEL. Everything else, regulated areas, exposure assessments, record keeping, hygiene practices, those are all gone. They remain, of course, in the General Industry Standard, but they're gone for construction and maritime. That's in proposed stage right now. That rule is not final, and so there'll be more heard on that as we continue into 2018. Just for a recap of implementation dates for the Beryllium rule, as I just explained, for construction and maritime, all obligations have been postponed except the PEL and STEL on May 11th. Employers in those industries will have to begin or make sure they are in compliance with both the PEL and the STEL. All right? I'll talk about what those are in a couple of minutes after Nick talks about silica. But that obligation is just about upon us. It's unclear whether that date will be moved back again or not. But I don't think we should count on that. So make sure you're in compliance in those industries. For general industry, the obligations, except for a couple of things, were to kick in as of March 12th. Because of the settlement negotiations ongoing with the agency delayed very temporarily, a very short-term delay of the March 12th date. It's now May 11th. So right now, everyone in general industry is expected to comply with all of the obligations of the General Industry Standard beginning May 11th, except for the engineering controls, which do not have to be implemented until March 2020, and the shower and change rooms, which have to be implemented next spring, March 2019. Okay. So that is just a quick recap of the beryllium obligations, and after Nick talks about silica in a little more depth, then I'll very quickly talk about the major provisions of the Beryllium Standard. I don't want to spend too much time on that one because, as I said, there aren't many of you, I'm guessing, who are on this webinar because of beryllium, but also because the settlement negotiations are ongoing, and that means there's obviously a chance that the rule provisions will change, so no point in spending too much time on it. Silica, though, it's settled. And so, Nick, how about we talk to our audience about the nuts and bolts of what's required by silica under the Silica Standard?
Yeah, thank you, Kate. My pleasure. So we're going to talk about silica, and we're going to focus primarily on the General Industry and Maritime sections, and more so the General Industry, because that's what's getting ready to go into effect here in a couple months, or go into compliance effectiveness in a couple months, as Kate mentioned. So, but just some general background on it is that, you know, what is crystalline silica? It's a component of the crust of the earth. So it's in soil, it's in sand, it's in other materials. It's pretty much everywhere. You know, it has been established that this is a human carcinogen, and it causes silicosis, which is in the lungs. It's similar to black lung that we probably have heard about before with regard to coal miners specifically, and there's also some review of whether or not conditions that we've been determining have been black lung in the past, could those be silicosis now? And that's more so from the MSHA perspective. But nonetheless, silicosis has really got a lot of attention. A lot of this stemmed from a spike in hydraulic fracturing a few years back. And then with the rule being promulgated around that same time, it has been a topic that has gotten a lot more attention than it did previously. So with that being said, we have our new regulation that is going to be in effect, or compliance deadlines, and we want to compare the general industry versus the construction. And when we're looking at that, there are some very similar aspects, such as the permissible exposure level and the action levels will be the same. But there are several differences, and just to highlight a few of those is, in construction, the construction standard, we have what OSHA calls their Table 1, and this is a list of specific tasks and actions to take while performing those tasks that will allow you to be exempt from the other requirements of the OSHA regulation on silica. The Table 1 exemptions do not transfer completely to the general industry regulation. There is a limited crossover in times when a task is indistinguishable from work being performed under the Table 1 in construction, but that task cannot be performed on a regular basis and in the same environment and conditions in the general industry. It has to be something that's somewhat of a abnormal situation. It cannot be a normal task that that industry person, general industry profession is performing. You're not going to have the total protection of the Table 1. Additionally, with construction, when we're working with our written exposure control plan, there is a requirement that in the construction side, you have to have a competent person available to implement that plan. And that is a provision that's not present in the general industry. So a little bit of a difference there. The requirements of the exposure plans are going to be very, very similar, but you don't have to have that competent person in general industry. There's also a provision of the rule for general industry that we have to limit access to areas where workers could be exposed above the PEL, and in those situations, we'll cover some specific guidance on how to regulate those areas. Lastly, there's a bit of a difference between who qualifies for medical exams between the two standards. And for general industry, that is someone who is exposed or at or above the action level for 30-plus days a year. And for construction, that is someone who is required to wear a respirator for 30-plus days a year. So just highlighting a couple areas where the standards for construction and general industry don't align. And so when we look at that, we can then look at when is the general industry standard going to be applicable to our operations. And we have to first determine if our exposure is going to be at or above the action level, or reasonably expected to be above that level of 25 micrograms per meter cubed over an 8-hour shift. And if that is determined that we will not exceed that 25 micrograms per meter cubed over an 8-hour shift under any foreseeable circumstances, then the standard doesn't apply. We don't have to do any more to apply the provisions to our workplace. What's important, though, is knowing what OSHA meant when they said under any foreseeable circumstance or conditions, because they consider the failure of engineering controls to be a situation that is reasonably foreseeable. So if we are at or below the 25 micrograms per meter cubed over our 8-hour shift because of engineering controls, and only because of those, meaning without those controls would be above that action level, we are still going to be subject to the provisions of the regulation, because OSHA has determined that a foreseeable condition is a failure of those conditions, or those controls, the engineering controls. So that's important to keep in mind when we're looking at whether or not this is going to apply to our operations. It's not just the testing, but also what might happen to our controls, and are our controls the only thing keeping us under that threshold. As I mentioned earlier, there's also specific instances when we, as general industry, can be protected or exempted from the regulation under Table 1, the construction standards, Table 1. And what we have to look at in there is an example that OSHA gives is if an employee is repairing or maintaining existing power delivery lines, which is considered a general industry task, and they use a drill that is the same as that used in installing new power delivery lines, which is a construction task, that person would be exempt. But what isn't going to be protected is if we are a general industry or maritime operator who is continuously sanding or cutting concrete blocks in a manufacturing plant, for example. That is something that there are specific provisions under the construction standard Table 1 that would exempt requirements that the company need to comply with the provisions. But since it is a regular task to be performed in the same environment and conditions on a regular basis, that general industry activity, the company would have to comply with the existing provisions of the regulation. They're not going to be exempt per Table 1. So there are very limited circumstances in which general industry is going to be able to claim an exemption under Table 1, and that's just something to keep in mind as we go forward with implementation. Looking a bit more at the specific provisions, we need to look at what are going to be the controls that are required to be implemented if we are at or above that action level. OSHA is very much looking for engineering controls over administrative controls. I think that's been well established throughout the life and litigation of this standard. And that's going to be ventilation, local exhaust, be it a hood over a specific area where you know there could be an exposure. It's also going to be wet methods, and specifically that's going to be targeting the areas of source, the dust source locations. And, you know, that could be isolation based on just blocking off the entire area if required or if available and feasible, or replacing the components so that you can totally isolate the dust that is within it. When we're looking at those, we have to make sure that we try to put in any engineering practices that we can, and that is to reduce us down below the Pell. Now, if we cannot feasibly put in enough engineering controls to get us below the Pell, then we can still use controls such as respiratory protection to bring our employees into compliance to avoid overexposure. But we have to still put in those controls. And I mean that is, you know, if we can't get our controls below that 50, that doesn't mean we can abandon all and put everyone in a respirator. This regulation still wants us to put those controls in place. In terms of work practices, it's another important aspect of the regulation that they want to have work practices which, first and foremost, focus on the continued improvement, maintenance, and functionality of our engineering controls. So we want to make sure that our employees know that part of our work practices on a daily basis are going to be analyzing how our controls are doing and what we can do to make them better. We also are going to look at how can we organize our schedules to limit exposure. That was a provision that was replaced or put back into the regulation. And also, again, that wet cleanup. That's a pretty big element of this. Respirators are still permitted, but they are not going to be a primary protective device, in that we have to take other steps, as we discussed previously. And that's because OSHA believes that there can be additional safety concerns present because of the use of respirators, such as inhibition of employees' hearing or sight or ability to communicate, and also because that only protects a specific person wearing the respirator, not the overall work site. In another area that we specifically talked about a bit earlier with limiting access, we want to talk about regulated areas. And if we find an area where exposure can be reasonably expected to be greater than the PEL, or 50 micrograms per meter cubed, we need to restrict the number of employees that have access to that area. And if they do enter that area, they have to be having appropriate respiratory protection. Now, how might we do that? We want to be able to limit the area or demarcate the area, and we can do so with the use of cones or tapes or barricades. Even textured flooring has been laid out by OSHA as an option for marking the boundaries of a regulated area. We also need to put some signage in place that's going to warn individuals who may or enter it of the risks, and that specific language needs to be danger, respirable, crystalline silica, may cause cancer, causes damage to lungs, wear respiratory protection in this area, authorized personnel only. So OSHA lays out some pretty specific language that they want us to use. And when we are talking about limiting access, it's authorized personnel, and that is going to be anyone who is working in or near the area that might have a source or an overexposure source. It also is going to be any maintenance personnel, management, quality control, or other people that may have to be in that regulated area. So it is not so sufficiently limited that no one can enter except for those specifically with a primary job function. However, we still need to look at limiting just foot traffic through areas as well as the ability of people just to generally enter. If we're reviewing the exposure control plans, which are another significant element of it, that has to be a written plan that we maintain if we're subject to the provisions. And there is specifically a number of elements that need to be included in that. And it's going to be description of the tasks involving exposure, the controls to limit that, and housekeeping methods that can limit exposure or dust creation. And the housekeeping is, again, we're going to see the wet processes, the work practices. That's a big element of this regulation. But specifically housekeeping methods, is a prohibition of dry brushing and sweeping unless you are wetting down the material first, which is going to be considered wet brushing, or using a HEPA filtered vacuum. And if those are not feasible, and again, the basis of feasibility is going to be very high to determine something is unfeasible, then we'll be allowed to take part in those activities. It's also going to be not allowing cleaning of surfaces or clothing with compressed air unless that is used in conjunction with a ventilation system. So some specific elements have to be included in this control plan, and also this has to be reviewed on an annual basis to determine how effective the measures and controls included in it are. And it has to be made available to any OSHA or NIOSH personnel or employees that might be subject to the provisions contained within. So there are some specific elements that we have to make sure are covered in this exposure control plan. If we are going to talk about the medical surveillance, right now the medical surveillance is going to have to be starting in June 23rd, 2018 until June 22nd, 2020, exposures for above the PEL for 30 days a year, or, and this is for general industry, for exposures above the action level after that 2020 date. So they're going to be become more restricted in who we're actually less restrictive and more inclusive in who has to undergo examination and testing. In terms of frequency, the exams have to take place within 30 days of starting a task that will result in exposure or upon the initial assignment or assessment. And that is unless that person's had an exam within the last 3 years per this Silica regulation. And the frequency is going to be at least every 3 years unless recommended more frequently by a medical professional. This medical surveillance, as expected, has to be at no cost to the employees. We have to be prepared to cover the cost of travel if that's going to be required, or cover the cost for time spent traveling and taking the medical exams. It's going to include a medical and work history review, a physical exam on the respiratory system, digital or film x-rays, and a lung function test, as well as some other requirements such as a tuberculosis infection test for latent tuberculosis. And then the initial assessment as well as the periodic assessments will have the same requirements other than that latent tuberculosis infection requirement. If we're looking at training, because training is going to be another significant element of this, we have to train on some specific topics, and it's going to have to take place when an employer asks an employee to perform a task that is new to that employee in an area that might have silica overexposure. When we introduce new protections, we're going to have to redo training, and we're also going to have to monitor our employees to see if retraining is required and if they're acting in a manner that suggests that they forgot what was learned in the training. And that's specifically going to be covered on the health hazards of silica, along with the tasks that could lead to exposure in our workplace, and all the controls and work practices that we've been implementing. It also is going to include reviewing the medical surveillance program as well as the regulation itself. So it's a specific, again, elements that need to be covered in performing this training, and it has to be performed when someone is going to be assigned to that task. And then again, if there's any changes in what we're doing, or if the person just demonstrates that they aren't capable of performing the functions per their training. If we are looking at similarities between the construction and maritime, we already outlined how they were different on an earlier slide. But again, we're going to have the same action level and the same permissible exposure level. Other than the competent person, the requirements are going to be similar for the written exposure control plan. Again, this is going to limit housekeeping and includes medical surveillance. The difference is going to be it's not to persons who are exposed above the action or the PEL for 30 or more days a year, but this is going to be people who are required to wear a respirator for 30 or more days a year. And primarily where it differs is the competent person. And before we move on, I'm sorry, the table 1, but before we move on, I want to briefly discuss competent person, because this is a component of the construction standard that's not present in the industry. And so a competent person has to be someone who is capable of identifying existing and foreseeable respiratory crystalline silica hazards and has the authorization to take prompt corrective action to eliminate or minimize these hazards. They also must have the knowledge and ability necessary to implement the written exposure control plan. So we need to find someone who is capable of looking at those specific elements and putting it into effect, as well as evaluating what new conditions might be occurring or developing on our site. A big element, and the biggest difference between the two, is the presence of Table 1. And we already briefly discussed how that may or may not transfer under specific circumstances for exemption under the general industry. But in the construction standard, there is a very specific set of activities, and they're listed on the screen right now. It's 18 activities, including in Table 1. And there has even been some discussion about increasing the activities listed in here, where if you follow OSHA's directions in Table 1, you are exempt from the rest of the requirements under the provision. And so we can see that there's a list of them, whether it's operating saws or drills or crushing machines or other kinds of machines that may produce a significant amount of dust, OSHA has developed specific work guidelines. And these guidelines have to be fully and properly implemented per OSHA. That is a phrase that they are going to use when they're coming out to look at compliance. And that means that the controls are placed, they're properly operated and maintained, and employees understand how to use them. And part of this fully and properly implemented is going to be following manufacturers' instructions for reducing and minimizing dust emissions. It also is going to include using respirators and using the appropriate respiratory protection per that table. And if we're looking at an excerpt from Table 1, and this one is particular to handheld powered saws of any blade diameter, so it gets very specific, but OSHA lays out here what engineering controls and work practices the employers need to implement when if they are going to satisfy and fully and properly implement this Table 1, and therefore be exempt from the other requirements. And we can also see down at the bottom that it has specific actions that need to take place when used outdoors and when used indoors or an enclosed area. And if we look over on the right, the next two columns, we see up at the top that one is for if there is work on this specific task less than or equal to 4 hours a shift or greater than 4 hours a shift. And for example, if we're looking at handheld power saws, if we are using a handheld power saw and we use the integrated water system to feed the blade and reduce dust emissions, and we're outside and we're using it less than 4 hours a day or per shift, we don't have to use any respiratory protection. That's why it says none. If we are doing that indoors, we need to use a respiratory protection or a respirator with an assigned protection factor of a minimum of 10. And if we're going to be doing it for greater than 4 hours per shift, whether we're inside or outside, that same requirement for the respiratory protection is going to apply. So, some other areas where we have to make sure we're complying, especially is going to be, do we have the right nozzles and right maintenance of our manufacturer's dust control system, as well as are we having the proper respirators being used. If we are doing those things, we are not going to be subject to the other requirements of the standard. But if we are not, we are going to be having to comply with other portions of it. And that's going to be the exposure monitoring. And that's going to be triggered when we are performing activities either not listed in Table 1 as a construction entity, or if we do not fully and properly implement those practices.
Nick, if I could just interrupt 1 second and share with the group that if you are an employer who is construction industry controlled Silica Standard, be aware that there may be some changes to Table 1. We do understand that there are negotiations ongoing with the agency to expand Table 1. So there may be some additions that you should become aware of. And obviously, Table 1 gives great relief for those tasks that are covered. So keep on the lookout for that. Sorry, Nick, go ahead.
No, that's fine. And also, this is, as we're butting up against our hour time frame, this is a good point to say. We hope that you all can stay on for the remainder of the webinar, but if not, we understand, and you will be getting a copy of the presentation along with the recording sent out afterwards. And also, if there's any questions that we haven't got to yet or that you want to send to us afterwards, please feel free to either put them into the chat function or email Kate or myself, and we'll get back to you after that. So, but with that, we want to talk about the performance monitoring, and this is going to be one of your two options for exposure monitoring under the construction standard. And this is going to specifically give us the opportunity to determine for our individual employees what their time-weighted average of exposure is. And it's going to be looking at a combination of both their monitoring as well as objective data. And by objective data, we're talking about industry-wide surveys, area sampling, as well as maybe historical air monitoring by us as an employer. And, we again are going to have to do a test when the work begins and reassess when a change in production might, or some other factor might alter what the exposure levels are going to be, or if there's any other reason to believe an exposure exists above the action level. So if we're not going to be doing the performance-based, we're going to be looking at the scheduled monitoring. And so obviously this is going to be what we would expect. It's not based on what's happening as much as it is a specific set of circumstances. So if we test when the initial exposure or the employee begins a task and there is exposures below an action level, we don't need to take any further monitoring. If we're going to be looking at monitoring that reveals exposures at the action level but below the PEL, we must repeat monitoring within 6 months. If our most recent exposure is going to reveal that it is above the PEL for that area, we must repeat monitoring within 3 months of the most recent. And then if we are in that situation and we get 2 consecutive tests that aren't an initial evaluation, they have to be at least 70 days apart, but no more, but within 6 months of each other, that are below an action level, we can stop monitoring for the scheduled base monitoring. So that's an important element. We also need to be able to notify affected employees of the results of their exposure and assessment within 5 days of completing it. And there's 2 elements there that are worth briefly discussing. And the first, affected means any employee whose exposure was assessed, or their exposure is represented by others who were tested, or those who have been exposure calculated by the use of objective data. Also in the 5-day period, notification starts for the performance once we finish the exposure assessment, and then for the scheduled, it's within 5 days of receiving the laboratory results. So a little bit different between the 2. When we get into the MSHA world, and we'll be brief with this, but it's a different world in that we're dealing with much different standards. And MSHA, for the purposes of the metal non-metal industry, essentially has 3 standards which apply to airborne contaminants. And it's not a specific silica standard. And, the one that is going to determine when testing must be completed just says as frequently as necessary. If we're going to be looking at specific elements, we have to, or specific threshold limit values, we have to look back to the 1973 ACGIH table. That is what MSHA still refers back to as their threshold limit values. We had one instance where, and it affects silica a bit, but the respirable coal dust rule was revisited and updated in 2014. And that did limit the amount, but that's silica is part of a much larger universe of dust collected. If we are in the MSHA world, we have to have a respiratory protection plan if we conclude that respirable silica or respirable quartz is going to be an issue. And this is going to look similar to what has to be included in the written exposure control plan under OSHA. And that's going to be employee training, written procedures, fit testing documents, training on how to properly use and clean and store respirators, records of actions taken in the process of training on respirators. There's a lot that goes into this that's going to be duplicative in what we see in the written exposure control plan, but under the MSHA guise, it's called a respiratory protection program. So if we determine through testing that we may have a silica source on site and we're above that TLV, which for MSHA is 100 micrograms per meter cubed, so double the new PEL for OSHA, we are going to have to implement these respiratory protection procedures. If we look at what's happening with MSHA, we are working with 100 microgram per meter cubed TLV. The TLV is just the ACGIH term, essentially, for PEL, and PEL is the OSHA term. They are just limiting the value through which we can be exposed. In the world of MSHA, typically we see the exposures taking place very quickly due to a exposure in a single event. There can be, again, exposures collected over a large period of time, but many in the mining industry are going to be saturation events such as changing out or preparing some kind of maintenance, and a significant amount of dust falls on you. And that is also going to be something that we see in the OSHA world as well, but especially so in the MSHA. From an enforcement standpoint, while MSHA still has the the regulation of 100 micrograms per meter cubed, there was a push to do some Me Too rulemaking after the OSHA regulation came out. That's now been pushed to long-term items in terms of the regulatory agenda for MSHA, but there's been some rumblings that there's consideration to maybe revisit it or look at it and see if some changes need to be made. And those are really just having developed in the last couple months from the MSHA hierarchy.
And everyone, sorry, yep. Nick, just so everyone knows, we're monitoring very, very carefully what MSHA is planning to do in regard to the silica regulation. Some of you are impacted, would be significantly impacted if if MSHA decides to do a comprehensive standard like OSHA has done in the form of, a quick Me Too rulemaking. So as Nick said, the agency's been a bit equivocal on whether it's going to go forward in that or not. There have been conflicting signs, so we're on it, we're watching it. We'll let the world know if we hear anything specific.
Yeah, Kate's most certainly correct there. We are paying attention to it, and we'll broadcast if there's any changes. And there's nothing imminent yet. It's still something that has been discussed briefly. So I will say, though, just briefly from an enforcement perspective, we've seen MSHA begin to enforce a lot of the provisions that we see in the OSHA regulation, and that is emphasizing both a long-term and a short-term approach of engineering controls, meaning they want to see a short-term fix to immediately remove a dust source, as well as an engineering control and work practices that are going to remove the source for the long term. There has been a pickup in the silica enforcement from MSHA in 2017, and it seems to be continuing at the beginning of 2018, especially in the frac sand industries and its affiliated industries. So I know we covered a lot of information very quick. I see there's a couple questions that we'll cover at the end of the presentation. But for now, I'm going to let Kate take off and discuss again a bit more of the Beryllium Standard with us. So thank you. Thank you all for your time.
All right. Well, we're significantly over the time we promised we would try to limit this to, so I'm going to try to really streamline this and talk for just a couple of more minutes. Certainly, as you know, we're readily reachable if you want to follow up on any of these topics. But let me just very quickly talk about the Beryllium Standard itself. Giving you a lot of background, the status of the rule. Anyone who is impacted needs to be ready to comply by May 11th. Here are the key components. The Pell, which obviously is the centerpiece of any comprehensive health standard, has been reduced by tenfold. It goes from 2 micrograms per meter cubed, which it's been since that 1948 AEC Atomic Energy Commission standard, adopted by OSHA in 1971, and now it is being reduced for the first time to 0.2 micrograms per meter cubed, which was the recommendation that was included in the model that was developed by the collaborative effort of labor and industry. A STEL is being set, a short-term exposure limit of the current Pell, which is 2 micrograms per meter cubed, for a period of time not to exceed 15 minutes. So that's essentially the ceiling concentration that you can hit for a short-term exposure. An action level is established at 0.1, 50% of the Pell. That's a very typical level that is established, half of what the Pell is for an action level. That will trigger a number of the ancillary provisions. And the ancillary provisions themselves, I find to be pretty typical of the, normal sort of suite of provisions that are included in OSHA health standards. There's as We talked a little bit about, with silica, the exposure assessment requirements, the initial exposure, the characterization of the workplace essentially, and then follow-up exposures depending on whether you have triggered an action level or a PEL. Excuse me, follow-up monitoring if you have triggered an action level or a PEL. You have to develop a comprehensive exposure control plan. I won't go into the details of that, but that is triggered for all exposures in the workplace, both under silica and under beryllium. It is not just triggered, the obligation to do one is not just triggered if you have an action level exposure. I think we had a question on that, but whether you have exposures in the workplace at all. Respiratory protection, of course, necessary where your engineering controls do not reduce exposures to the PEL. Regulated areas, demarcated just with signage or whatever to make clear to employees you're in an area where there's an exposure. For beryllium, the exposure above a PEL or a STEL means you are in a regulated area, and that means needs to be handled separately. No one can go in there except the worker who's supposed to be there and certain other select people that are listed clearly under the regulations. The unique aspect of the beryllium standard includes the establishment of what are called work areas. I'm unaware of any other occupational health standard that has this requirement for work areas to be identified. I'm not going to spend any real time talking about that except to point it out that it exists. As I've mentioned multiple times, we are involved in settlement negotiations. The regulations may change, so there's no point in kind of understanding what this is. But note, if you are an employer who is impacted by the beryllium standard, you need to not only be aware of your regulated areas, but you need to be aware of your work areas. And the current definition of work area under the standard includes basically all areas where you have an exposure to beryllium. Those have to be handled separately, and they trigger separate requirements. And then the normal stuff, PPE, medical surveillance, housekeeping, hygiene, labeling, communication of hazards, training, record keeping. And as I said earlier, there is a medical removal provision in the beryllium standard. Okay, so please follow up with us if you want to learn more about it. Just one note on the maritime and construction standard. I think I already pointed this out. There's a proposed rule out there. OSHA has proposed to strip away all of the ancillary provisions, leaving just the PEL and just the STEL, and they announced in an enforcement directive that they are going to begin enforcement of the PEL and STEL in the maritime and construction industry as of May 11th. All right, chemical rulemakings. Okay, 3 minutes on chemical rulemaking generally. A lot of this stuff is just, I'm whatever. I'm too a geek or whatever on chemical rulemaking of the agency. I follow it pretty carefully. The agency has failed woefully in the area of chemical rulemaking. We have, essentially about 10,000 chemicals out there in U.S. workplaces, and there are all of 31, by my count, I could have that off by 1 or 2, but about 30 comprehensive occupational health standards like the beryllium rule and the silica rule that we just described that have been promulgated in the entire history of the agency, okay? There have been 3 in the last almost 20 years, including beryllium and silica. And again, maybe I'm off by 1, but I'm pretty close. There is Table Z, which, as you all probably know, has a whole slew of PELs, essentially the legal limit, but there's no, sort of comprehensive umbrella provisions around those. It's just the PEL. No requirement for exposure assessments or record keeping or hygiene, et cetera, just the PEL. You've got to meet that. But even of the Table Z limits, there are only, there are less than 500 of those to regulate 10,000 chemicals. Of those 500, a huge majority are, like the beryllium standard, the old beryllium standard, the 2 microgram per meter cube limit, a limit that my client industry, everyone recognizes as woefully out of date. So there's a huge problem that OSHA's got in promulgating these chemical rules. Now, query is that the way that chemicals should be regulated? Should it be by government regulation? Should industry be doing this voluntarily? Many, 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 many of you are regulating to a much lower level than OSHA establishes. But, I don't think I'm speaking out here against the agency. That is not my goal here, and it is not what I'm doing. In fact, I think Dr. Michaels, if he were standing here next to me giving a presentation on this, would say exactly the same thing. At many speeches he gave as the Assistant Secretary of Labor for OSHA, he made the same point that I am making, that the agencies, the process is broken essentially, and there are so many obstacles to developing chemical standards. So, and here's a chart that I put up that the agency has on their website, I think, that shows all the various steps the agency has to go through to develop a chemical standard. I think the head of the Economic Analysis Division of the Directorate of Standards and the Directorate of Standards indicated that it takes between 12 and 16 years to promulgate a rule. So that system isn't working. The question is, what is the new Assistant Secretary going to do? What is this new agency going to do under President Trump? Are they going to change anything fundamentally about the way rulemaking is done, chemical rulemaking at OSHA, or are we going to see a continuation of essentially industry doing its own self-regulation by promulgating its own standards that are applicable to it, and sometimes through product stewardship are available and used by downstream customers? Lots of obstacles, lots of questions. OSHA in 2014 wanted to start this national dialogue. It had some meetings around the country. It issued an RFI asking for industry to comment. How can we do better? How can we help you develop limits? One of the steps that OSHA took was to establish an annotated table, and to my surprise, somewhat of a surprise, the agency continues, even in the Trump administration, to keep the annotated table on its website. The annotated table not only lists the OSHA PELs, those PELs that show up in Table Z, but it lists all of the voluntary, non-mandatory, non-legally binding standards that have been set by various volunteer organizations like NIOSH, the NIOSH RELs, the ACGIH TLVs, California's standards, which tend to be much lower in many instances than OSHA's PELs. And I put chromium up here on the slide just to give you an example, where OSHA has a PEL for chromium of 5, that's a typo there, that should say microgram per meter cubed. ACGIH's limit is 0.01. So huge difference in the standard. OSHA put that table on the website to try to get to, without being able to do actual rulemaking, to revise rules or set new rules, to try to push these lower limits. But, big question, can OSHA rely on those lower limits to, in an enforcement context, can OSHA actually enforce those non-binding limits? When you've got an actual standard for chromium of 5, can they bring say a general duty clause citation for violation of the ACGIH standard? That seems to a lawyer, sort of nonsensical. But there are 2 instances that I'm aware of. General Dynamics case, a relatively old case, 1987, where the agency cited employer for violation of the Freon Table Z limit, and the commission, the ALJ and the commission vacated it, saying, no, that you can't, you've got a Freon standard, the company met the Freon standard, they didn't meet you can't rely on the general duty clause to cite someone for violation of the OSHA Act when they are meeting the specific applicable standard. And in fact, there's a regulation that OSHA has promulgated, I think it's 1910.5, that says that you can't cite an employer, or it says essentially if you're in compliance with a specific standard promulgated by OSHA, you are deemed in compliance with Section 5A1. Not so according to the General Dynamics case. Fiberdome, it settled, it never went to litigation, so we don't know the outcome. That was a more recent case, 2014, but same concept. OSHA used the general duty clause to cite a company who was in compliance with the styrene PEL of 100 parts per million for violation of the general duty clause because it had an exposure above the NIOSH REL. Now, there's complicating factors there. There was an industry agreement to comply with the voluntary standard, so who knows? bottom line, we don't know where this is going. Query whether this is an opportunity for the Trump administration to do something creative, to work with industry, to develop processes, protocols that can be implemented maybe voluntarily, but the agency can help industry as opposed to using kind of the hammer of enforcement. Two ideas that I'm going to talk nothing about, but have gotten some, oomph behind them. Hazard banding, control banding, basically where you band groups of like-performing chemicals together and you regulate by bands as opposed to by particular chemical, and informed substitution, this process that OSHA encourages where you basically inventory your chemicals and you make decisions about which ones you can eliminate and the impacts of all that holistically on your company. Okay, we're way past time. I'm going to stop talking. Thank you all very much. We'll be happy to answer questions via email after. We'll deal with the questions you've already submitted. Thanks so much for your time. I hope you enjoyed our presentation.
All right, thanks. And we do have a couple questions, Kate, just to get us started on that are still outstanding. I'm going to lump two together because I think we can qualify or quantify the answers at the same time. But it is what employers must have an exposure control plan for general industry, and how does monitoring requirements apply in the general industry. And so a written exposure control plan is going to have to be implemented and developed if the standard applies. So that is going to be if we determine if there's any exposure greater than or equal to the action level of 25 averaged over an 8-hour shift, or if that is not the case, and it will not be the case under any foreseeable conditions, then we do not have to put a written exposure plan into place. And the exposure monitoring are going, for the general industry, are going to be those either scheduled or performance-based monitoring that we discussed for construction. And there's one more question, Kate, that I'm going to turn over to you because I think this might be something you can shed some light on. But it says, what is going to be the effect of individual companies having to satisfy the silica rules if there's going to be exposure created by a subcontractor and they have people working in the area? Will the company of the employees who are not creating the dust but being exposed to us going to have to comply with that regulation?
Okay, well that's an interesting topic. It will be very fact intensive. It will be decided by the agency using its multi-employer citation policy. OSHA identifies multiple employers who have some responsibility depending on the facts for compliance with applicable standards like the Silica Standard. So if you, for instance, are a host employer, meaning it's your facility, you control the facility. Exposing employers, you are not the host, but you are the one creating the exposure. There are 4 types of employers. I'm going really quickly here, but there are 4 types of employers who potentially would be held liable under OSHA's multi-employer citation policy. So just because you're not creating the dust, if you are the host, meaning you own or operate the facility, you may have responsibility depending on the relationship you have with the sub, depending on what that contract term, what the terms of that contract with the sub say, depending on your ability to control the employees at your work site. So I don't really want to go further than that because I think I have to understand a little bit more about the facts, but let's follow up on that one if we can.
All right, very good. And then if there's any other questions that we haven't discussed, please feel free to contact either one of us at our information on the screen or anyone else in the Carey Workplace Safety Practice Group. We are happy to be a resource for anyone at any time. So, be sure to check out the OSHA Defense Report blog and also the MSHA Defense Report for any developments between the 2 agencies on silica rulemaking or beryllium rulemaking. And we appreciate everyone joining us today, so thank you very much.